Well, there's a few reasons for that, sir. You know, one of the main reasons is I'd like some clarification on the record to be made without getting arrested due to the last appearance. As you know, was physically unable to get there. You're right about my motion. I didn't prove the just cause. I realized that I had to include some exhibits and proof that of what was going on, and I apologize for that. However, um, the last appearance, I was specially appearing to, by special appearance, I was attempting to make it by a special appearance to challenge the jurisdiction of the court due to several issues that have been unaddressed through the entirety of the case. The main ones being the discovery violations, the most recent changing of the discovery files to make all my motions look like I don't know what I'm talking about, and kind of confused a lot of the matters. And it's still the same thing. I mean, just a couple days ago, I got notice that there was another discovery update. I mean, we're well past the motions deadline, and there was a discovery update a week before that, and then another one like a week after, and then now more recent ones. And I just don't really feel like that's really granting me a fair chance at really defending myself when they want to change the names of the files and things like that. As I've like already had submissions that had certain citations to their body cam footages and things like that have also been unaddressed. It doesn't really provide grounds for fair defense or a reasonable amount of time to be able to defend myself.
All right. Thanks, sir. All right. Here's, I guess, the record I'm going to make. We're set for trial to commence on Tuesday. Mr. Mann, I recognize how you are perceiving this, but I think the record is pretty clear. This case has been going on since 2022. By my count, there are at least 8 failures to appear, and that's at least 8 failures to appear in this case. You've after an Arguello advisement, you've agreed to represent yourself. You were advised and cautioned during the Arguello advisement that you would be required to, when representing yourself, to comply with the rules of criminal procedure, with any rules of evidence during the admission of any evidence. That has not actually even become ripe at this point because we've not had any hearings. This matter's been set for hearings to address your motions on a couple of occasions just since I've been the presiding judge over this case. And I believe in, let's see, let me just want to make sure I'm, yeah, on 11/26, that just myself have granted you extensions to file certain motions, giving you specific deadlines. And on 11/26/2025, I made it very clear what the final deadline was going to be for your motions to be filed, specifically 12/12 of 20.
All right, guys. Today we're going to watch a defendant who truly believed court rules were optional for him. This case starts with Jacob Mann already having a warrant hanging over his head. Yet instead of showing up in person, he casually logs in through WebEx and immediately starts arguing about jurisdiction, discovery conspiracies, and unfair treatment. The wild part is how confident he sounds while ignoring the fact that he already failed to appear multiple times before this hearing even started.
2025. Then we were scheduled for a motions hearing on 1/9/2026. That was the day that you appeared via WebEx. I found a failure to appear because you appeared via WebEx and did not give a adequate reason. You had indicated that you may be able to get here by 10:30, and I even stayed the warrant to give you that opportunity. Today, we're set for pretrial conference 1 week away from the beginning of the trial date. You're still not here in person. These motions that you keep on talking about could have been addressed appropriately if you would have followed the court's orders during that time frame. And certainly, if there are issues of discovery that have happened that are not in compliance with Rule 16, the court will hear those. But those, again, you've been complaining about, or challenging, I should say, discovery issues, but you never present yourself on a date that we're actually scheduled to address those things. And you have to be here in person. You also have to be here in person for the trial. So again, we're set for a pretrial conference here. I have a jury questionnaire that I'm going to submit to the jury commissioner in preparation for Tuesday's trial. I'm going to bring in 55 jurors for that trial, and the court will be prepared. Well, let me ask the prosecution. Is the prosecution ready to go to trial on Friday? I'm sorry, on Tuesday.
People are ready, Your Honor.
All right. So, Mr. Mann, we're set for trial. I mean, this, again, I'll address any pretrial issues or any discovery issues that have arisen in the last 35 days to determine whether there was any discovery violations. One thing you need to understand is the prosecution has a duty to continue to provide discovery. Oftentimes when they provide discovery just based upon, and I don't know how you're receiving your discovery, but again, these are just things I'll consider. And I'm just saying this for your information. Sometimes when they provide discovery, if they're doing it over what they call evidence.com, which is a system that they use to disclose information, sometimes not the new discovery is provided, but then all the previously provided discovery kind of tags along with it. So it's included with it. I will address any discovery issues that may have arisen in the last 35 days if there's any new discovery that may exist. But those are things that I have to address when you're here in person. You're not here in person. I think I know you're aware that you have a warrant based upon the orders, the motions you filed and the last order I issued in this case. But we are set for trial on Tuesday. You have a right to a trial, and the court, and it looks like the prosecution are prepared to proceed on that date. I will provide you with every opportunity to defend yourself at that trial. We will see you on that date. At this point, I don't know that there's anything else I need to go over pre-trial unless Ms. Jones and again, Ms. Jones is here only as advisory counsel, unless there's something in particular that Ms. Jones you think I should be covering, or unless Mr. Duncan wants anything in particular covered. The one thing I will state is just based upon the nature of how things have been progressing in this case, I'm not going to require any witness testimony on Tuesday, so that at least there's a one-day window there for the people to just place any witnesses on call for.
Buckle up, guys, because this is where the judge completely takes control of the courtroom. While Jacob keeps insisting the system is unfair to him, the judge calmly walks through years of missed hearings, ignored deadlines, and repeated chances that were already given to him. You can literally hear the patience wearing thin as the court explains that every issue Jacob is complaining about could have been handled properly if he simply showed up like everyone else is required to do.
Yeah, no, I'm actually done with that.
Okay, I should have interrupted sooner. If Mr. Mann is not here today, are you finding that it's a failure to appear?
It is a failure to appear. I'm just giving him the information so we can proceed on Monday. He's got a warrant already. So yes, it is a failure to appear. But I still want to pass the information along so we can proceed on Tuesday. I said Monday. On Tuesday's the trial date.
So, excuse me. You said quite a bit there. I didn't really get a chance to respond to anything.
There's nothing to respond, sir. I'm just giving you
instructions. I got some things I need to address with the court before we can proceed, sir.
Well, sir, then you need to come to court. We will address those things when you're here in person.
Well,
I'm not going to.
I'm trying to tell you guys need to prove jurisdiction because there was a period of time I sat in prison for almost 9 months and there was no action on the case. That's a failure to prosecute. And I understand the statutory provisions on speedy trial, but there's constitutional provisions. And if the trial ain't had from the date of the start of the case between 180 days and there ain't good cause shown, that means you guys waive jurisdiction.
I will address, sir. I'm
asking
covered everything I need to cover.
I'm
Sir?
asking you to address it now because before we can proceed, I need you guys to prove that you guys have authority to try the case.
Sir, I've already addressed way more than I needed to. You're not actually here. It is a
No, I
failure to
am here.
appear. I am
you
protecting your right to a
You
fair
waived
trial.
my rights to all my motions. I mean, without me even knowing it, I didn't give proper notice of that waiver of rights. You can't just be taking people's rights. I mean, the Constitution forbids that, and Constitution trumps everything. It doesn't matter what kind of order or ruling of law. If it's against the
All right.
Constitution, you know that you can't be ruling
All
like
right.
that. So,
We are
can you address that, please?
We are, all right, sir, what I'm addressing is that you're not here. And the one thing I will say is you were on notice as to what the motions date was, and you failed to appear on the motions date. You
Well,
have
no,
to be in
actually, I
person.
attempted to appear
in
by
court.
video because I couldn't get there, and I wish the record would reflect that. Because I did try
Sir,
to-
the record is made on this case. Okay. This matter is now in recess.
Okay.
You have a trial on Tuesday. You need
That's
to be
cool.
here in person for your trial.
Yeah, I got you. You don't want to
All
give
right.
me nothing, I got you. That's pretty much.
All right, guys, this is the exact moment the case shifts from messy courtroom drama into full sovereign citizen territory. Jacob interrupts the judge, demands proof of jurisdiction, starts lecturing about constitutional authority, and acts like the entire trial cannot continue unless the court answers directly to him first. Meanwhile, the judge barely reacts emotionally and simply keeps repeating the same devastating point. None of these arguments matter because he still failed to appear in person.
E2 CR 2848 Jacob Mann, entries of appearance.
Todd Duncan for the people.
And Miss Jones, Jessica Jones is here as advisory counsel for Mr. Mann. Mr. Mann is not in the courtroom. I guess I'll just ask, do either party have any information relating to Mr. Mann as to why he's not here today?
No record,
Okay.
Your Honor, that I
All
can
right.
make on his behalf. I don't represent him.
No, I understand. Just didn't know if there's any communication or anything, but all right, we're set for trial. I'm going to make well, let me find out. Is there any record that, and Ms. Jones, I 100% recognize that you don't represent him, but is there any record you need to make of any kind?
Your Honor, I have been in touch with Mr. Mann as he has been attempting to prepare for his trial this morning throughout the long weekend. I know that he is scared, he is confused, he has many questions about how to proceed as a pro se individual. I did my best to try to assist him in that manner, but I don't represent him.
No, it's fine. It's fine. I just, all right. I need to make a record. So, because frankly, based upon the nature of this case as a whole, I think the court needs to take some appropriate action on the bond issues on this case. So I guess I'll go back to the last court date, which was on 2/10 of 2026. Mr. Mann, that was set for a pretrial conference. And Mr. Mann, at that point, kept on arguing or was trying to argue that the court lacked jurisdiction, and based upon what he was saying, he indicated because the case has not been brought to trial within a certain period of time. He was presumably making some kind of a speedy trial argument. So the court believes that it's relevant to make this record both to establish why, at least based upon the court's review of the record, there's not ever been an issue of speedy trial in this case. And two, why at this point, I believe a new bond, I mean, he's already on a bench, there's already a bench warrant that has been issued in the case against him, but the court finds that a bond modification is now required for his failure to appear at trial. It was made very clear to him on 2/10/2026, even though the court found that he failed to appear because he was on WebEx, the court at least gave him the courtesy of explaining to him how jury selection would go, the fact that there's a trial and that he was expected to be here for the trial. This case has been set for trial now 4 times. This is the 4th trial setting. The first trial setting was continued. Well, he pled not guilty back in 10/10 of 2024, so October 10 of 2024. And most of this is based upon the court's review of the record. That's when he pled not guilty. The trial was set for 9/25/2024. I'm sorry, I just confused the record here. I'm sorry. On 4/10/2024, he pled not guilty. Speedy trial was then 10/10/2024. And the trial was then set on 9/25/2024, so before the speedy trial date. There was a 35 days, an order from the court for the defendant to file motions 35 days prior to the motion setting date, which was set on 8/2/2024. That matter was continued at the defendant's request, and a second trial setting was then set. So the new speedy trial date on the second trial setting, which was set on 7/30/2024, then became 1/30/2025. That new trial date, I'm sorry, that was a new speedy trial date. The new speedy trial date was now 1/30/2025 with a new trial date of 11/13/2024. New motions date of 10/4/2024 and a pretrial conference date of 10/25/2024. The defendant failed to appear to the motions date, to the pretrial conference date, and the trial date for the second trial setting. The defendant then next appeared on February 28, 2025. The matter on that date was set for a setting on 4/7/2025, and the judge that presided on that date ordered that speedy trial was tolled until the next court date. So the speedy trial then was 10/7/2025 per that court order. The defendant failed to appear on 4/7/2025, which was the setting date for that trial date, and a bench warrant was issued. The defendant then appeared again on 4/9/2025, and on 4/9/2025, the defendant indicated that he was.
Buckle up, guys, because the judge is about to unload the full history of this disaster piece by piece. What makes this section so brutal is that every excuse Jacob tried using completely falls apart once the timeline gets exposed in open court. Missed motions hearings, skipped trial dates, repeated warrants, and endless delays all get laid out one after another. And after hearing the entire history, the judge finally decides enough is enough and slams him with a massive $100,000 cash bond.
Hiring private counsel, but may go pro se. So the court advised the defendant pursuant to Arguello, and the matter was set for trial on 9/10/2025. And it appears from the record that the defendant accepted the trial date that was set on that date. Court again set motions due date 35 days prior to the motions hearing date, which was then set at 7/11/2025, and a pretrial conference on 8/26/2025 was set. The defendant failed to appear to the motions date of 7/11/2025, failed to appear at the 8/26/2025 pretrial conference date, and failed to appear to the now third trial setting, and second failure to appear on a trial setting by the defendant that was on 9/10/2025, and that was a waiver of speedy trial. So now we're set on the fourth trial setting. The defendant was arrested on a warrant on or about 9/22/2025. On that date, the court saw the defendant. He indicated he had motions to file. Since the court was set the matter for trial, the new speedy trial date, which is the speedy trial date that applies to this particular trial setting, is 3/23/2026. The court appointed advisory counsel, Ms. Jones, well, who ended up being Ms. Jones. I don't think she was identified on that date, but who ended up being Ms. Jones, and allowed the defendant an opportunity to file motions to show cause as to why motions should be allowed to be filed late, and set the case for trial on today's date, so 2/17/2026. 26. Pretrial conference was 2/10/2026. On 9/23/2026, the defendant made clear that he did not want the public defender to represent him, and again, he had been previously given an Arguello advisement. Court then set 11/24/2025 as a date for which the defendant could file motions, if good cause could be shown for any delays. Court then set a status conference the day after those motions were due on 11/25/2025 to allow the defendant to basically have a status on where we were on motions. And on 11/25/2025, the minute order will be corrected if it hasn't already. The minute order at one point was reflecting it was on 11/26/2025, but the court has actually gone and listened to the FTR. It was on 11/25/2025 that the defendant appeared in court, and the court extended the deadline for the motions to be filed further to 12/12/2025 and set this matter for a hearing on motions on 1/9/2026 at 9 a.m. So on the trial setting here, he had the hearing on motions date of 1/9/2026 at 9 a.m. He had the 2/10/2026 date for the pretrial conference date, and then today's date for the trial. The defendant failed to appear at the hearing on motions. He appeared via WebEx, which the court indicated the court would not accept, and the court gave him about an hour and a half to get to court after he stated that he may be able to get here, and the defendant did not show on that date. The defendant then appeared to the pretrial conference, as previously mentioned, via WebEx, and the court indicated that, again, that was a failure to appear, and the defendant needed to be present. So the court deemed that to be a failure to appear. But again, the court at least used the opportunity to try to increase efficiencies on today's date if the defendant appeared for trial. And Ms. Jones specifically had asked that the court do this. The court did provide him with the procedures that the court uses for jury trial. So this case is now set for a fourth trial setting since the defendant first entered his not guilty plea. It's been continued once at the request of the defendant, and speedy trial was waived, and at all other times it's always been continued because the defendant has failed to appear to every single hearing after the first trial setting, to every single hearing that dealt with either a motions hearing, a pretrial conference, or the trial, including today. So as this is now set for its fourth trial setting and the defendant is not here, the court believes that a bond modification is required for what the court has previously posted, because it is clear the defendant will not follow the court's orders on such important dates that are actually set up to protect the defendant's rights to a speedy trial, which is what he keeps complaining of, but he's not, based upon the record, the court finds that it is his doing as to why.
All right, guys. After spending some time in custody, suddenly the same man who wanted to challenge jurisdiction and fight the system at trial is now ready to accept the plea deal immediately. It's honestly one of the fastest attitude changes you'll ever see in a courtroom case. The confidence disappears, the arguments calm down, and now he just wants to simplify everybody's time and move on. Let me know what you think about this entire courtroom meltdown. And if you enjoyed this breakdown, make sure to like the video, subscribe to the channel, and we'll see you in the next video.